Okay.
You got it.
All right, let's see. Where's Miss Francis? And you co-host me back, Miss Francis. Okay, everybody. This is your Orca bond hearings for Fulton County Superior Court. And all that I ask everybody to do is, number one, if you're in the booth and I call your name, when I call your name as we go down the counter, if you'll just wave your hand, because I want to make sure that your lawyers see that you're here also. And then I ask that you folks just please, please, please let me finish talking. That's it. Just let me finish talking for you. Don't interrupt me, you know, and I try to be really sometimes informative. So I'll tell you if I see something that shows up on Odyssey, there's an outstanding warrant, that's information. Do with it what you will. But please don't argue with me because I'm just reading what I see on Odyssey. Just so you know that it's there. Okay? So if you would, like I said, just please just don't interrupt me so we can get through this as quickly as possible. And we're starting with the Cobb, I guess. LT? He usually likes to start up there with Cobb.
Yes, ma'am. Go ahead.
All right. So is that Ronald Brown? Ronald Brown?
Hi, Judge.
All right, there he is. Okay. All right, Ms. Rockwell, we got position 11, pre-trial, 22 CP 208-200. Got Ronald Brown. Theft by receiving stolen property, unlawful for a person employed or associated with criminal street gang to conduct or participate in criminal street gang activity, and fleeing or attempting to elude a police officer. As on July the 12th, 2022, there is a $800,000 good bond. Trial.
22 cycles, Your Honor, at least 4 probation violations and 4 FTAs in the past 10 years, a 2014 conviction for aggravated assault, burglary in the first degree, theft by receiving stolen property, 2018 conviction for possession of a Schedule 4 controlled substance, a 2019 theft by shoplifting, a 2021 conviction for theft by shoplifting out of Gwinnett County. Defendant was sentenced June 24th, 2021 to 5 years probation. And in addition, Judge, there are 4 holds. The first hold is out of Douglas County, FTA hold. There's a probation violation hold out of DeKalb County, a probation violation hold out of Gwinnett, and a hold out of Atlanta, Georgia for a stolen vehicle case. Nothing further, Your Honor.
Ms. Rockwell.
Judge, that hold out of Atlanta, I think is this case. And by the way, Judge, I do have the victim on the line. I'm going to email you, Judge, her ID. Who's my prosecutor, Judge? I'm sorry.
To be ADA Hiles here.
Hey, Reeves. I'm going to send you a copy of her ID also. Just for the record, Judge, he is 26 years of age, born in Atlanta. I didn't send it yet. I'm talking right now, and went to Douglas High, did not graduate, but did get his GED. He then went on to school to study for electrical. And he is also trying to get his CDL. If he'd be out right now, he'd be trying to be almost wrapping up in December with his CDL course, because his father is an owner operator and has 2 18-wheelers. He is not married, but he does have 3 children, 8-year-old, 3-year-old, 1-year-old. He does have a 1-year-old with the alleged victim, who is on the line with us, and who's also the one that retained me in this matter, Judge. So he would like to get a reasonable bond so that we could start dealing with some of these outlying matters, if you will, the violations, etc. So she's on the line to state that he would, and I can put her under oath, Judge, or just let you know what she would testify to. But the first thing I'm going to do is send you guys both a picture of her ID. And that's Reeves and Judge Manning.
It's 197 days incarcerated without indictment.
And I don't know if y'all want to talk to her or not, Reeves, without me being on the line or whatever, but she would not want him to be sitting because of her. He would have permission to drive the car, etc. So I'm thinking that if I could just hurry up and get it in front of a judge, like with an indictment, Judge, because I know you can't make us sit down and talk and make the prosecutor talk to the victim and all that kind of stuff. I know that you don't really have, that much control over Mr. Hiles, but I hate for him to be sitting on this when I've got the victim who owns the car and would never want him. She's got a 1-year-old with him. So anyway, I'm asking for a $35,000 bond, no further violations of the law. And I think that, the gang charge is because there's a criminal charge. I think we had a hearing were you with me, Reeves, when we had the hearing?
Not on this case.
Okay, we had a hearing and the judge didn't even find that he was in a gang. Anyway, that they met the burden of showing that he was doing any kind of gang activity. So there you have it. So I'm just going to ask the court to strongly consider a $35,000 bond, no further violations of the law, please.
Where's he going to be living, Ms. Rockwell?
Well, with her and his 1-year-old.
That's Fulton County? That's Fulton County?
Say that again?
That's Fulton County?
I forgot
Are you going to be living in Fulton County, sir? Thumbs up or thumbs down, best you can. All right, thumbs up. All right, what says the state?
Am I hearing you right, Ms. Rockwell? Are you saying that the gang charge was dismissed?
It wasn't.
No, I'm saying that we had a hearing. It was a contested probation revocation. I think I'm telling you correctly. I mean, it was a real live hearing, and she showed up and, said, "I'm not prosecuting him for being in this car."
Your Honor, I understand what they're saying. I'm just going to ask for $35,000 on each case, on each charge. He does have a substantial criminal history. We do feel like he is a threat to flee. Maybe not. Yeah, threat to flee based on his previous failure to appears, a threat to reoffend. But I do understand also balancing that with the amount of days that he has been incarcerated. I cannot speak as to exactly when this will be indicted.
And I just want you to know, Reeves, she's going to be the one she's at work right now.
No.
She's going to be trying to make the bond. That's all I'm asking for, Judge.
No drugs unless prescribed, no alcohol, no weapons. If she lives at the Jonesboro Road address.
Ma'am, is that your good address right now? Or do you need to get your driver's license updated? Oh, maybe she doesn't know how to answer.
All right. Sir, is that where she lives? Jonesboro Road?
No, that's not my address.
Hold on.
Sorry.
The incident date is 1553. Ma'am, yes or no? Is that where you live?
No, ma'am.
Thank you. All right. Stay away from 1553 Jonesboro Road. You can have an ankle monitor paid for by the county. 24-hour curfew except for medical, court, or to see your lawyer. No further contact with any gang member, Goodfellas gang members, any gang members. No possession of replicas of weapons. Let's see. No driving. An ankle monitor, like I said, is going to be paid for by the county. Let's see. The theft by receiving stolen property. All right, we'll reduce that to 5,000. Count 2, 100,000. Count 3, I'll leave it at 25,000. Best of luck to you, sir. You leave the booth.
Judge, if he could make that bond, he doesn't go, he doesn't
And
do,
you have 48 hours to have that ankle monitor placed on your ankle after you're released from any of those holds. Thank you,
And-
Ms. Rowe. I knew where you were going. You got 48 hours to have that ankle monitor placed on. You got a lot of different places to go.
would he be able to go to school, Judge?
Well,
work? I'll get with the prosecutor.
perfect. All right, let's see. We got Eric Mosley. Thank you, sir. All right, Mr. Teal, Kendall Teal here.
Judge Manning, I'm so sorry. I hate to interrupt. Manel Shahimi on behalf of Mr. Sebastian Zamudio. You signed the order, Judge. I just wanted to confirm we were excused.
Yes, ma'am. That's your only
Okay.
case? That's your only
That is
case?
the only case, Judge.
All right, thank you. Have a good evening.
Thank
Judge,
you
an
to your
interpreter
honor.
is appearing on that case, position 12. I mean, right? Sorry, that's.
I don't think, no, we need an interpreter today? I didn't think, nope, no interpreters needed today.
You have
It's
12 and
Ken-
25, Judge. Thank you. then.
Yeah, they said, thank you. Kendall Teal. Is
Your Honor,
anyone,
Your Honor, Frederick Mann on behalf of Mr. Mosley, can you hear me?
I can hear you, but I need to see you.
Okay, well, I'm trying to bring up my image and I'm having a little technical difficulty. As
All
this-
right, we'll go to the next one then. All right, Demetrius Beck, till you get your camera fixed. Demetrius Beck.
I'm here for that case, Your Honor. Mike Jacobs. And he's
Demetrius.
in
All right.
one.
Here we go.
All right. Position 18, pretrial, Eric Mosley, 22 CP 210655. Yes, Mr. Mann. Or
Yes,
Mr.
Judge.
Okay.
I don't want to interrupt the court after your admonition to us all, but you let me know and I'll tell you what we think the situation is here.
The attorney for Eric Mosley. That's you, right, Mr. Mann?
That is correct.
All
Yes,
right, here
ma'am.
we go. 22 CP 210656, 104 days without indictment. Got insurance fraud, forgery in the first degree, theft by taking felony, insurance fraud, forgery in the first degree, 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 forgery in the first degree, theft by taking felony, insurance fraud, forgery in the first degree, theft by taking felony, insurance fraud, forgery in the first degree, theft by taking felony. I think I got all those, right? Madam Clerk, trial. Oh, and this incident date started around 4/9/2020. Go ahead, pretrial.
26 cycles. Felony convictions include a 2009 financial identity fraud out of Fayette County, a 2010 forgery in the first degree, financial identity fraud that's out of Clayton County. Also a 2010 a separate 2010 financial identity fraud out of Clayton County, a 2012 conviction for identity fraud out of Henry County, and a 2018 theft by deception out of Clayton County. In addition, Your Honor, there are at least 4 FTAs and 4 probation violations in the past 10 years. Nothing further to add.
All right. Go ahead, Mr. Mann.
Your Honor, Mr. Mosley is a native Atlantan. His partner is with me. You can see her on the screen. Her name is Alexis Christine Upshaw. She has 4 children. She has a full-time job, 40 hours at the airport. The children are cared for by a grandmother. Mr. Mosley has an open job offer to work for his father, who has a landscaping company full-time. His partner, Ms. Upshaw, is a vehicle and can take Mr. Mosley back and forth to court as needed. Mr. Mosley also has a vehicle that he can use to go to court. He was recently the subject of a robbery and an assault at least once, if not twice, with a sharpened object. I'm not sure what kind of shank it was, but it was at the Fulton County Jail, and for that reason, he was moved over to the Cobb County Jail. My understanding is that this is a series of claims that were made to Geico for a broken windshield on 2 cars. And unfortunately, the neighborhood Mr. Mosley had the cars in was one where people routinely smash windshields. The claims were submitted. The only checks that Mr. Mosley received that I understand from the facts is 2 or 3. The other checks were received by other persons. He owes, Geico. Apparently, the only claim that I saw in the warrants was a grand total of $998 or thereabouts. The state has not indicted him in the 100 and some days that you mentioned. He has one brother and three sisters here in Atlanta. This is a close Atlanta family. They have cookouts throughout the year. They stay close with each other. He and his partner went to church on a regular basis. The church is behind her residence in public housing with her 4 children. And I think Mr. Mosley is an excellent candidate for release. Honestly, if not on his own recognizance, then on a nominal bond.
All right, what says the state?
Yes, Your Honor. The state is asking for a $5,000 good bond per each charge, 20 charges total. With respect to Ayala, we'll submit there does seem to be a pretty substantial threat to property, significant danger to property based on the nature of these allegations. We do understand it's a number of insurance fraud claims, but the concern is real. We'll submit there is a substantial likelihood of reoffending pending trial, given the history, including a number of felony convictions involving property, as well as a risk of not returning to the jurisdiction to face charges given the 4 FTAs. Nothing further from the state. Thank you, Your Honor.
Where's he going to be living, Mr. Mann?
Your Honor, he would live with his mother at the 3280 Bethsaida Road address in Atlanta.
Okay. All
And,
right.
I'm sorry.
No, that's okay. No drugs unless prescribed, no alcohol, no weapons, no further contact with anyone from Geico. Right now, we'll do 5,000 per count, Ms. Parham. Best of luck to you, sir.
Thank you, Judge. How many counts are there altogether? I'm sorry.
20 per my count.
20.
20.
All right, now we got Demetrius Beck. Thank you, sir. You can leave the booth. We have Demetrius Beck in there.
Thank you, Judge.
Thank you. Eric Mosley, you can leave the booth. Thank you. We don't have Demetrius Beck, so let's go back to South. Eric Mosley. Okay, that's down there. All right, let's see. How about we go to Erica Hughley? Go ahead and help us South Annex. All right. That's position 14 and 15.
This will be 88 Majeski, Your Honor.
All right. Let's see. 94 days without indictment, pretrial, position 14, 22 CP 210896, forgery in the first degree, knowingly filing a false document against a person.
I need to join the.
Who's
Mr.
talking?
Ivory, can you please keep your microphone muted?
All right. Knowingly filing a false document against a person ×2, impersonating another in the acknowledgement of a recognizance bail or judgment, forgery in the first degree. There's 3 counts of that, false statements, and 1, the unauthorized practice of law. And there was no bond on that as of July 23rd, 2022. Position 15, State of Georgia versus Erica Hughley, 22 CP 212559. Forgery in the first degree, identity theft and fraud when using or possessing info concerning a person, false statements or writing, conceal facts or fraudulent documents in matters of government, knowingly alter, conceal, cover up, create, and file a false document, impersonated another in the acknowledgement of a recognizance bail or judgment, unauthorized practice of law, forgery in the first degree. And I'm sorry, there are 2 identity theft fraud when using, possessing, identifying info concerning a person. Trial.
10 cycles. Last felony conviction was in 2004 for theft by taking and forgery. And there's also two separate cases in 2004. The second case is for financial identity fraud, forgery, and financial transaction card theft. And nothing further, Your Honor.
All right. Callaway.
Yes, Your Honor. It would be permissible for me to share my screen. I have some exhibits that I would like to show the court.
For Ayala?
Yes.
Okay. As long as it's Ayala.
Yes, Your Honor, of course.
Oh, Judge, while she's doing that, can you hear me? My microphone was messing up earlier.
Yeah, I can.
Okay, thank you.
It's okay.
I think I need permission to share my screen.
Hold on 1 second.
Okay.
All participants. Okay, try it now.
Okay, I'm trying it right now. It's, okay, here we go. It still won't let me share it, but I can continue until we can get that. It's still saying I need permission to share.
Go ahead.
Okay, but I'll go ahead and, because I don't want to waste the court's time. So, Your Honor, Mrs. Hughley, and also I want to just first point out by saying that her name is in fact Mrs. King. She was booked in under Mrs. Erica Hughley. Erroneously, she was arrested for a warrant out of Florida, which turned out to be resolved. So her name is actually Erica King, but she's booked in under as Erica Hughley, and that becomes important because some of the documents that I have say Erica King on that, but that is in fact her true name. So I'm sorry, Erica King. Erica King is 46 years old, and she was born and raised in Atlanta, Georgia, with and around her family and friends. She lived in Atlanta most of her life. She did leave briefly to attend college, but moved back to Atlanta and is currently living in the Roswell area. She attends Greater Zion Hill Baptist Church in Smyrna, Georgia. I had a letter to show the court from the deacon saying that she is a regular attendant and that the church will be there to support her while she's going through this case. She's enjoyed a decade-long career as a publicist and has a degree in that field. Her past employers include Turner Broadcasting, WSB-TV Atlanta, and many others. She also volunteers at the Covenant House Atlanta, which is a shelter for homeless teens. So she's very active in her community. But one of the most important things that I want to point out about her not being a significant risk of fleeing is that Mrs. King was arrested on July the 11th, 2022. During that time, her home was searched. She knew that this case was going on, that these allegations were being alleged against her. But she was booked in and she was released. She did not attempt to flee. When they came back to rearrest her a couple of days, about a week or so later on July the 11th, she was there at her home. She was allowed to dress, get her prescription medications, and be taken into the facility with no incident. So we think that is important for the court to know. Also, she poses no significant threat or danger to any person, community, or property. And another one of my exhibits where when she was first booked into Fulton County Jail, just like every other inmate there, she was given an interview by pretrial services, and after reviewing her history, their release recommendation was that she meets the criteria for unsecured judicial release. So that's what we will be asking for today. For nearly 2 decades, she's had no felony convictions, as we just heard from pretrial, no failure to appear, no violent charges. There are no violent charges in both of these cases, no probation violations. And so again, pretrial services and their pretrial report, which I have here, just states that she meets the criteria for unsecured judicial release. Also, she does have a co-defendant in this case, but she poses no risk of intimidating witnesses. Actually, that co-defendant was her employer. These allegations stem from her employment and her involvement in that person, which we are finding out more and more that he has a pattern of manipulating women and getting them to be involved in these types of things. So we think that she was just kind of taken advantage of in her course of employment. But of course, a no contact order, Ms. King has no reason and no desire to contact the co-defendant in this case. But most importantly, what I want to say about Ms. King is that when she was arrested in this case, she had just been diagnosed with multiple sclerosis. As I'm sure the court is aware, it's a debilitating disease of the brain and spinal cord. It attacks the central nervous system. So basically her immune system is attacking her central nervous system, and she's having trouble communicating, that communication problems between her brain and the rest of her body. Before she was brought into custody, she lost sight in her left eye, which is how she was alerted to go to the hospital and be diagnosed with this. Since then, I have a letter here from her doctor, Dr. Diana Vargas, with the Brain Health Center, the Emory Brain Health Center, who wrote me a letter letting me know that she was diagnosed with multiple sclerosis and she had developed optic neurosis, again losing sight in her eye, and as of now she has 10 lesions on her brain. And so because of this, if this disease is not treated, it will progress, and she could possibly end up being severely disabled. The South Annex Jail does not have the capabilities and the resources to provide her with this much needed medical attention. The only thing they can give her right now is pain medications. So when she was booked in with a list of 10 medications. She brought the medications with her that she gave them to Fulton County Jail, gave them to the nurse, and they were supposed to be administered. Some of those prescriptions just cannot be administered or cannot be fulfilled by the jail. So she's in custody now, and she's in South Annex, which we are all aware South Annex is, just to be completely truthful, the conditions.
The challenge.
Yeah, they're deplorable. I mean, she because of her condition, she can't sleep on a bunk, so she's basically sleeping on a boat on the floor, and that means that when the jail floods, which it does often, she's laying her pallet is laying in feces and food. And with this medical, the more I go see her, the sicker I can tell she is. And there's nothing that South Annex can do to accommodate her condition. And so we are asking that she be released on an ankle monitor so that she can take care of these health problems and come back to court. And again, her history is showing, even though she 2 decades ago, she may have had a felony history, sure, but she was able to successfully complete her probation and no violent charges right now. And also I want to point out, she has been in custody for 93 days with no indictment in violation of OCGA 17750. So technically she's entitled to a bond. So we're asking the court to set a reasonable bond today with conditions so that she can get out and take care of her medical illness. And also, and I, of course, I know I've been speaking with the state. I know that there are more charges that they are to come. I've spoken with her about her possibly speaking with the state and resolving these cases. So it could be we may not be there yet, but it could be a point where we're going to be walking her in under a proffer to kind of resolve these cases, because so many are coming out of this, just a few transactions. And if you read the warrants, a lot of this stuff is repetitive. A few things happen, and they're hitting a lot of charges. And so we would just ask the court to take that in consideration and grant Ms. King a bond today.
What does the state, oh, and by the way, just real quickly, Ms. Keller, where is she going to live?
She is going to live in Roswell.
Fulton County, gotcha. What does the state?
What's the address in Roswell?
1701 Napa Valley Court, Southeast Smyrna, Georgia. Is that correct, Ms. Hewley? That's correct.
I apologize, Judge, and
Sorry.
I apologize for asking that, Judge. I just wanted we need to drill down on all the facts in this case, because there's a whole lot of fraud going on here. Okay. Nice to see you, Judge.
You too.
Nice to
Good
see
to
you
see
as well, Ms. Calloway. I have heard about the MS thing before, and we did ask, at one point, can we see some documentation of this? We haven't seen it yet. I heard her say that she has a document. I haven't seen it. What we do know about this defendant is she has 3 open cases in Fulton County: 22 CP 212559, 22 CP 210896, and 22 CR 00421G. That misdemeanor is important, however, in this case, because that misdemeanor involves her sister and involves slashing her sister's tires. And that same sister is the person who has full custody of Ms. King's child. And if you actually go back and read the bond motion filed by Ms. King in this particular case, it states that Ms. King has full custody. She does not. We've spoken to Corliss King in this case. So whatever Ms. King was trying to get across there, it was not truthful. Ms. King's statement. I need to correct the record quickly on her history. She actually has 11 cycles in Georgia, Judge. There was a 2002, and these are all convictions, by the way, 2002 financial identity fraud, forgery in the first, financial transaction card theft, guilty. That was out of DeKalb County, 03CR1972. There was 2002 ID fraud, financial transaction card fraud. Those were guilty. That was out of Fulton, 04SC24263. There was another 2002 ID fraud ×4, that was guilty, 04SC16142, out of Fulton. And then there was a 2003 theft by taking, forgery in the first ×2, guilty, out of Gwinnett, 03B32963. Now, the defendant in this case has used many, many names, 5 that are really important to this case, including the identities of people from other states. In fact, when her house in Roswell was raided in this particular case, They recovered documents from other people, and just a quick list of things that will let you know how deep this case goes. And this will likely be a RICO case if it goes forward. Now, I did hear Ms. Calloway talk about a proffer. I do think I heard police inform me about that earlier. And I do think that Ms. Calloway and I had mentioned it briefly one time. So that might be a thing. I'm not sure. Okay, I couldn't speak to that, but this will likely be a RICO case if we have to indict this. The reason it's not indicted yet, because we do have full information, is because there are additional warrants coming, at least 2 more sets of warrants she's going to end up being arrested on here, Judge, all spanning from other things that are going on here. The 2 cases that are in front of the court today have to do with her perpetrating a fraud on the court, actually in Fulton County. She was actually stolen an attorney's identity named April Holloway. Her identifying information was found in Miss King's house when it was raided by RPD. In fact, one of these hearings was actually broadcast from the house that was raided by RPD in this particular case. There's actually a very kind of funny picture with the detective in the case sitting right in the chair that they actually broadcast the hearing from when they actually raided that place. But just to give you an idea about what's going on here. When they raided that house, the defendant, to first of all get the house, she had posed as a real estate agent, got paid by the people who were renting the house, and then proceeded to forge the documents, use the lease those houses, and at that point, never pay rent. So that was a fraud right there. Then after they moved in, things that were recovered there: fraudulent documents related to attorneys who were identities were stolen by her. We know of 3 at this point. Fraudulent notary seal, fraudulent superior court stamp, fraudulent law firm documents. They actually created their own fraudulent law firm in this case. And I mean, they did a lot to create it too. It was actually impressive. I admire the work ethic that was put into this fraud. They fraudulently filed documents with the courts. They had stolen IDs from different schemes involving other defendants. They had forged court bonding documents that they had, and these things looked real. We had to dig deep to find out with the various people that they were not, as a matter of fact. They had blank stock certificates. They had forged car titles, which they've actually been filing in multiple states, not just the state of Georgia. They had forged bar documents in their house, Judge, for other. They had certificates of standing for India Young, who, by the way, she had posed as in 2019. In a 2019 CR case. That case was actually null prost in Fulton County. It was a forgery in the 3rd degree, but still, she did that under the name India Young, which also comes up in this particular case. There were documents with the seal of the state of Bar of Georgia on them. It's just dishonest, untrustworthy. Nothing that she says can really be believed. When the police showed up at the raid, and she said that she had to have some medical equipment with her, and I confirmed this with them again the other day to make sure I hadn't heard it wrong. She said that she had an oxygen tank with her. The only problem was it wasn't actually hooked up. It wasn't doing anything, but she claimed that it was. She also said that she was having a medical emergency on scene. EMS was called to tend to her. There was nothing wrong in that particular case, Judge. She is an ANC recidivist. I would also like to point that out to the court as well. Let me see here. In both of these cases that are in front of the court today, she lied on a Zoom call. These are both on Zoom recordings that we have the video of in the DA's office, Judge. She lied about who she was. The second call was actually, she wanted to have a hearing. It was in front of another judge. She wanted to have a hearing. She put up her name, April Holloway, at the bottom. She said she needed to present evidence to the court, logged off, logged back on, and April Holloway disappeared and Erica King appeared at the bottom. She told the judge very quickly, "Oh no, that's my paralegal." Well, it wasn't her paralegal, it was actually her. And the person sitting next to her in both of these hearings, as Ms. Calloway has referred to, that there's another co-defendant involved. There is indeed, was the co-defendant that Ms. Calloway was talking about earlier, and that is Mr. Ernest Williams. The amount of fraud that's going on here, it's not that she stopped doing it. We've talked to people in her life going back years at this point. It's not that she ever really stopped doing it. It's that she got better at it. And it took a while to get caught. And now that she has been caught because they got so brazen about the fraud that they were perpetrating on the court, she has charges most likely coming from other jurisdictions potentially at this point too. along with her co-defendant. We're still waiting to see how that irons out. But that said, Judge, when we take a look at Ayala here, when we take a look at the risk to reoffend, whether she's likely to commit a felony, she's not just likely, she's certain to commit a felony. And when she's released, and she is entitled to a bond at this point. Ms. Calloway is correct on that point, but she is certain to commit a felony. Her history of brazen fraud is actually remarkable in this case. They got away with it for a long time. Her risk to reoffend, almost a certainty. Her likelihood to reappear, this is a tough one, but she had stolen identities from people in several states. At one point, she had warrants for her out of Florida. I don't think those warrants are active anymore, or I would have announced those to the court as well, but I don't believe that they are. But her co-defendant certainly has warrants active in other states, and her co-defendant had at one point talked about leaving the country. Also, with as much skill as this defendant has at forging documents, and trust me, it is a lot of skill. I mean, there are some good forgeries, but forgeries nonetheless. We are really concerned about her skipping out. It's easy to cut. Oh, it's easy to cut an ankle monitor and run, Judge. The likelihood to influence a witness, I don't really see necessarily any evidence that that would necessarily be the case, so I don't see a need to drill down to that one. But as far as the risk that she poses to the community, she's stolen people's identities, she's harmed reputations, she's abused the judicial process brazenly, and we know that she's committed crimes across state lines. Like I said, she's been washing car titles in other states. I believe it's Wyoming where she's washed several of them, or Montana, or one of the two at this point. We know that there's been activity in Tennessee. We know that there's been activity in Florida. And I believe it's Texas and Arizona also have activity as well from this particular defendant. When we take all those things into consideration from the state's perspective, we think about what bond she should be assigned in this case. I think nothing less than a $10,000 cash bond per charge would be appropriate in this particular matter, with terms of not to leave the state, to surrender her passport in 24 hours, to be given an ankle monitor, and this is if she's able to make the bond, to be under 24-hour house arrest with the exceptions of medical and court, and to have no contact with victims in this case, being Shirley Strawberry, which is also the wife of the co-defendant in this particular case, Mr. Ernest Williams, April Holloway, Nicholas Benzine, India Young, Tammy Strong, and Sheridan Strawberry, who's the daughter of Shirley Strawberry, have no contact with their defendant or co-defendant, Ernest Williams, and to not associate or reside with any known felons as well, Judge.
Great.
Your
So, can we make it quick?
Sure. I just wanted to point out, so I was able to get it open. I do, and just show the court where it says she meets criteria for unsecured judicial release.
No. Yeah, I saw the pretrial report.
Okay, and then this is also a letter from her doctor, Dr. Diana Vargas, stating that she does in fact have multiple sclerosis. I even went as far as to went and print off some of the MRI.
So one thing is that we're streaming on live stream, so that medical stuff probably shouldn't be shared.
I blocked out all of her. I went and redacted things that I thought would be, that I thought would that are I blocked out all sensitive material. But just really quickly, Your Honor, let me get out of sharing my screen here. Really quickly, a lot of what the state has said are just allegations. And as the court knows, the defendant's guilt or innocence of the underlying charges are not an issue at the bail hearing, especially since the defendant enters the proceeding cloaked with the presumption of innocence. All we have heard now are allegations so far. What we do know is that she has not been convicted of a crime since 2004. That's 2 decades ago. So right now, she enjoys a presumption of innocence. Her criminal history is 2 decades ago. And most importantly, she's suffering from a debilitating disease. And to give her a bond in
Booth 3 North, Booth 3, sit down. 3 North, Booth 3, sit down. Go ahead.
And to give her a bond for $10,000 charge is essentially granting her no bond. And she has been booked in and released and didn't run.
Yes.
And the ankle monitor is sufficient. We would ask the court to set a reasonable bond in this case.
No drugs unless prescribed for physician 14, Madam Clerk. No drugs unless prescribed, no alcohol, no weapons, no further contact with the co-defendant Ernest Williams and Mr. Majeski. I've got Shirley Strawberry, April Holloway, and what are the other victims?
Nicholas Benzine, Judge. India Young. Tammy Strong, and Sheridan Strawberry.
Got that, Ms. Parham? Madam Clerk, you got it?
Judge, I got it. I couldn't get to my mute.
Oh, okay, all right, all right. You're gonna have an ankle monitor paid for by the county out of the ORCA funds, 24-hour curfew except for court, lawyer, or seek medical attention. Don't leave the state of Georgia. Got to surrender your passport. Let's see. On count, okay, so position 14, I'll do 5,000 per count. 1, 2, 3, 4, 5, 6, 7, 8, 9. So that's 9 charges on that. Wait a minute. Hold on, let me get the right number. Nope, it's 13. Right, Madam Clerk?
Yes, Judge.
Okay, so it's 5,000 per, because we got aggravated identity fraud times 4 false statements. All right, so that's 5,000 on each count. You can do the math on that. And then on position 15, we have those that I called off, and I'll make those 7,000 per count. And there's 10 counts, right, Madam Clerk? Because you had the 2 and another forgery and another identity theft added also.
Judge, it should be 8 total for that one.
Okay, there's 8. Okay, because it was 7 and 8. So that's 8 charges at $7,000 a piece. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant. Don't leave the state, surrender your passport, and that ankle monitor will be paid for by the county. You can leave for court, lawyer, or seek medical attention.
Oh, Judge, was that going to be cash or surety or cash as the state requested?
I'll tell you what, we'll make it cash. Best
Thank
of
you,
luck
Judge.
to you, ma'am. Oh, and Miss, let's see, Miss Calloway, on Odyssey, just so you know, there's warrants from 2003 and 2002, just says foreign warrants, 2 for identity fraud, 1 for deposit, a bad check. Just may want to check on that on the back end to make sure that there's nothing, if they shouldn't be there, that they're not holding your client, okay?
Yes, Your Honor. Thank you.
Ms. Calloway, if you need to reach out to me, feel free to give me a call at any time as well. Okay.
I will.
Thank
All right, Carla Robinson.
Your Honor, may I be excused?
Yes, ma'am. Good to see you. Carla Robinson.
Same request, Judge.
Sure, absolutely.
Thank you, Judge.
All right, Carla Robinson. We got the attorney for Carla Robinson. Yep, I see you there. All right. 22 CP 209754, pretrials 2,637 days out indictment. A $30,000 split bond as of June 10th, 2022. Trafficking methamphetamine, possession of heroin, possession of drug-related object. Trial.
3 cycles out of the state of Illinois, Your Honor. No felony convictions. Nothing further.
All right. Mr. Herrick.
Good afternoon, Judge. Ms. Robinson, as has been pointed out, has been in jail for 124 days without indictment. She was arrested in June of 2022. And if released, she would live with her mother, Carolyn Robinson, and that would be on Custer Avenue, and I believe that's in Fulton County. And her mother works at a facility caring for elderly residents. And when she was arrested, Ms. Robinson was working at Scottish Rite. She was working on a custodial team there. She was a lead on that team. And prior to that, she worked at Kellogg Warehouse, and where her brother, Tevin Huey, was tragically killed. And that was just about a year before. It was June 30th of 2021. And he was at work where she also worked. And my understanding is she witnessed him get into an altercation with another employee who pulled out a gun and shot him. And there's an AJC article on it. And that episode has understandably really affected her family, her whole family. Her biological father was killed in 1994 in Chicago. She's from Chicago. She was born in Chicago. And one of her other brothers, also with the same name, Carl Austin, as her father, he was also killed in Chicago in 2015. Her family moved to Atlanta to get away from the Chicago violence, and she moved here in 2017. So she put down roots here. She's been living here. She's been working here. She's attended some college courses in the medical field, looking at getting a certification there. And as I said, she was working at Scottish Rite. She doesn't have a felony history. She had a couple misdemeanors in Chicago. I don't believe she has any failures to appear or anything like that. And she does have a $30,000 bond here, but her family doesn't really have the resources for that. And if released, she would be living with family. She would resume working. If she can't go back to Scottish Rite, she would probably get a similar job. She's got her GED. She had dropped out of high school. She was pregnant at the time and she dropped out of high school, but she immediately went and secured her own GED. She wasn't required to do it. She wanted to do it. And that's the kind of person she is, Judge. She's caught up in this case where my understanding is, according to the warrants, 3 people are in a car, they get pulled over, and there's a backpack in the back seat. The driver says it's hers, she says it's his. The third person doesn't get arrested. And that driver was Mr. Perry. And Mr. Perry, in 2020, was arrested in DeKalb County for trafficking, methamphetamine, and possession of heroin with intent to distribute. MDMA with intent to distribute. He was arrested on a number of drug charges, very similar, released on a $5,000 bond from DeKalb. So I think that if she's released, she'll be able to help me with defending her in this case, and I feel pretty good about her chances. Sorry, Judge, I want to check my notes to make sure I haven't left anything important out. Yeah, that's all, Judge.
Yeah.
Yes, Your Honor, I'm showing a $30,000 good bond, 25 and 5. Third charge is a pretrial charge. We're asking that Your Honor allow it to remain. The state has not heard or seen any significant change in circumstance that would warrant a bond modification at this juncture. We do appreciate the relative lack of history. We'll look at the amounts. I'm showing 31 grams, and I'm looking at Judge Brasher's order, which shows it's $25,000 for possession of methamphetamine. I'm showing an unknown quantity of possession of heroin. We would submit with respect to Ayala, there is significant danger posed to the community with the alleged possession of these substances. Given the nature of the charges, maybe some likelihood of reoffending pending trial as well. We'll note there was a syringe loaded with a clear brown fluid recovered from the tan backpack. Nothing further from the state.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendants, Kenneth Perry or Jarvius, Jarvious Taylor. No drugs unless prescribed, no alcohol, no weapons. You're going to have an ankle monitor paid for out of the ORCA fees. You have a 24-hour curfew except for court, lawyer, or seek medical attention. Stay away from 344 Edward Street Northwest. Let's see. 20 on count 1. I'm going to leave count 2 at 5 and 3 went through UJR pretrial. Best of luck to you, ma'am. All right, I got D'Amica Malcolm. Thank you, counsel. If that's all you got, you can leave also. D'Amica Malcolm. Is Mr. Melnick here yet? I guess Mr. Melnick's not here yet.
No, Judge, not yet.
Okay, sorry, South Annex. We just got this one, but we're waiting on Mr. Melnick. So, all right, now I got Demetrius Beck.
I'm here in that case, Your Honor.
All right. If I could just gently and kindly remind people that I read all these warrants, preliminaries, or in the morning. All right. There's 4 cases for Demetrius Beck. As pretrial start count, position 6, 22 CP 211-022, 90 days without indictment, got robbery. There's no bond as of July the 28th. Then you got 7, 22 CP 211-024, Criminal damage to property, second degree, as of July 28th, no bond. 22 CP 211050, robbery and terroristic threats, as of July 29th, no bond, same thing. All these are 90 days without indictment. And 22 CP 211051, robbery and terroristic threats, as of July 29th, there's no bond, been in 90 days. Rah.
3 cycles out of the state of Alabama, 12 cycles out of Georgia, at least 4 FTAs in the past 10 years. In addition to the cases on the calendar, Your Honor, there is an additional open case out of Fulton County under 22 CP 209820. That's possession of tools for commission of a crime, criminal damage to property in the second degree, and misdemeanor charges for possession of marijuana less than an ounce and loitering prowling. And nothing further to add, Your Honor.
All right, go ahead, counsel.
Judge, briefly on his cycles, I don't believe, and pretrial may know better, I don't think any of them are felony convictions or felony arrests. I think they're all misdemeanors. I think he has a lot of suspended license and misdemeanor marijuana cases in the past. As far as these current cases, I think all 5 cases, one of the 5 already has a bond. I think they're all going to end up on one indictment. I think they're all a series of a pattern of crimes. Obviously, he denies it, but that's not what we're here for today. I did talk to his boss. He does have a job at RSS Incorporated as a project manager. It's a trucking and warehouse job, and his boss said he could start immediately when he gets out. He does live here in Atlanta. He lives at 55 Maple Street in Atlanta, Georgia. His grandmother is either on this call or on the public call. She's the one who's going to be posting bond. She's limited in her means, but she wants to help her grandson. What I was going to ask for, Your Honor, would be $10,000 on the robberies and $5,000 on the terroristic threats and the criminal damage to property.
So, Mr. Jacobs, I got that that's a courtyard, Marriott, that's a hotel. So where's he going to be living?
Oh, that's the address his grandmother gave me. I'd have to put him on to find out where he's going to be living.
Yeah, I mean, that's a hotel. So.
Can I put Demetrius on to say where his address is? That's the address, or his grandmother, I think, might be on this call. She couldn't log on to the public one. I just got an email. Her name is Gloria Blake.
Sir, do you know where you're going to live? Because I'm sure you're not going to be living at that Courtyard Hotel. You're going to be living at the Courtyard Hotel.
No, my address is going to be, see what happened? My house was recently.
No. Just tell me your address, sir.
55 Maple Street Northwest.
And that's Courtyard Motel?
No, it's an apartment complex.
All right.
Off Northside Drive.
All right, you can put him back on mute. All right, go ahead, Mr. Jacobs. Anything else?
That's all I have, Your Honor. Could I clarify that he has no felonies on his record? Is that correct?
Right, yeah. Well, not that she called off.
Okay.
Anyway.
Okay. So I don't think his grandmother can make, there's already, I think, a $20,000 bond on the 5th case. It's already in place. I think it's $20,000. I don't think grandma can make more than about a $50,000 total bond. So I'd like to structure it somehow in that parameter.
All right. What says the state? Mr. Norwood.
Thank you, Your Honor. With respect to the case ending in 022, the state is asking for $7,500 good. The case ending in 024, $5,000 good. 8 and 9 would be $7,500 good on the robbery, $2,500 on the terroristic threats. That, per my math, it puts us at 22.5. The state is deeply concerned about the threat posed to the property and to the victims here, Mr. Robert Smith and Nicole Duster. We would submit there is a significant risk of reoffending pending trial as well as a significant risk of not returning to the jurisdiction should the defendant make bond. We have not made contact with Robert Smith or Nicole Duster. A victim locates will be sent. Chase Bank and Truist Bank will be receiving letters from the state, Your Honor, but we are requesting a stay away from all locations, as well as no further contact with the victims, Smith and Duster, as well as any other conditions Your Honor sees appropriate and reasonable here. Nothing further from the state.
All right, Madam Clerk, position 6. No drugs unless prescribed, no alcohol, no weapons, no further contact with Robert Smith. Stay away from 1115 Howard Mill Road. Stay away from all Chase Bank locations. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court and lawyer and medical. Going to have an address if you move that's got to be supplied by the state. Position, and I'll do the 7,500. Position 7. $5,000 good bond, no drugs unless prescribed, no alcohol, no weapons. Stay away from 711 Lee Street Southwest. Ankle monitor paid for by county court lawyer and seek medical attention. Position 8, no drugs unless prescribed, no alcohol, no weapons. Stay away from altruist banks. No further contact with Gregory Burton. Also stay away from Chase banks. You got an ankle monitor paid for by the county. You can leave for court lawyer, seek medical attention. Stay away from 825 Martin Luther King Jr. Drive, and no further contact with Nicole Duster. Position 9, 7,500 on robbery, 5,000 on terroristic threats, felony. No drugs unless prescribed, no alcohol, no weapons. Stay away from 1598 Piedmont Avenue Northeast. No further contact with Gregory Burton. Stay away from 1825 Martin Luther King Jr. Drive. No further contact with Nicole Duster or Robert Smith. You can have an ankle monitor paid for by the county with a 24-hour curfew. You can only leave for court, lawyer, or seek medical attention. Best of luck to you, sir. You can leave the booth.
Judge, will he be able to work, or is that not going to be permitted?
What's going to the state?
As long as we have verification of the hours and proof of employment, no objection.
All right. There'll be a work exception if it's the hours, his location, and a schedule, everything where he'll be working. You got to turn that over to you. You got to turn it over to the state. And I'd also let that ankle monitor company know, or they'll turn him in.
Okay, that sounds
Thanks,
good.
sir. All right.
Judge, I missed the amount. 7,500 robbery and 5 on the terroristic threat.
7,500 robbery, 5,000 on terroristic threats. Yes. Who said Judge?
Thank you, sir.
Francis or
That was me. But you just repeated it. 7,500 on robbery and 5 on terroristic threats for position 8 and 9.
yes, ma'am. All right. Timothy Hickson. All right, there you go. Lawyer here for Timothy Hickson. Skipping Timothy Hickson. Hold on, sir. What about
Judge?
Yes.
Judge, sorry, I don't mean to interrupt you. Sorry, I don't mean to be out of line either, but I actually had an emergency. I'm with a family member at a hospital. And so I just wanted to know what number be on the calendar, Rashida Smith. So if I have to run up, using a conference room actually in the doctor's office here. So I just wanted to know and get an idea.
Is your person out and just a bond modification?
Yes, and she's here and I'm here. And I just wanted to get an idea. She's out. You gave her a bond.
All right, hold on. We'll take this out of order really quick. Hold on. All right, this bond modification, 22 is position 21, 22 CP 208792, possession of MDMA, possession of marijuana less than an ounce. Anything I need to know pre-trial?
Is this last name Smith?
Uh-huh.
No,
Yes,
no.
Ms. Smith.
All right, go ahead, Ms. Ross.
Thank all the attorneys who allowed her to do that. I know everybody is equally waiting, so I do appreciate that.
Not an
Ms.
emergency,
Smith was
that's
arrested.
okay.
Thank you. Ms. Smith was arrested back in May. No previous convictions, never been in trouble, no danger to community, doesn't have any TPOs, has never been in contact with the co-defendant to this day. Actually, when she found out drugs were in her house and that he was harboring drugs in the house, she immediately went and got a divorce. You actually signed her TPO. It came out, I think it was about a month ago, that he had been contacting her from the jail over your order. So I don't know if you remember the case. She has not violated. She has not done anything outside of the bond conditions, but the husband has and has continued to contact her since she was last in front of you, because I didn't actually have the original bond hearing, but her daughter has been accepted to Albany State. And the reason why we filed bond modification is because it's on the third page. It says,
is it all through pre-trial? Is it pre-trial? She can't travel?
Correct. She
right.
cannot travel. She can't even leave outside of Atlanta. So she wants to be able to go back and forth to take daughter out lunch at Albany State. Her grandmother has recently died. There's another family member in the hospital, and also she is the executor of an estate in North Carolina. She just wants to be able to travel. She has hired our law firm to be on the case. She's not going anywhere, and we just want those bond modifications to be able to allow her to be able to travel and come back freely.
Hold on. All right. Pre-trial, do you show anything showing that she's not complying or anything, Ms. Harvey? Do you know?
Checking right now. One moment, Your Honor.
All right. Go ahead, Mr. Norwood. Do you have anything?
We'll leave this in the hands of Your Honor. The state has no position.
You're breaking up a little bit, Ms. Ross. Hold on.
Okay. No, it looks like she's been in compliance.
All right, here you go. Here's what I can do, but you're gonna have to draft this whenever you get back, and hopefully everything's going okay for you, Ms. Ross. That's fine. She's gonna have to let pretrial know ahead of time.
Excuse me, Your Honor. Did we lose her? This is the court reporter.
No.
Okay. I think
Did
we
we?
lost her. I don't.
This was a.
Sorry, I think you lost me, Judge. It's a very bad connection here in the hospital. Can you hear me? Testing.
I got you. Nope. Okay, here you go. I'm going to modify.
Perfect.
Okay. She's going to have to let pretrial know ahead of time when she's going and a schedule, how long she'll be going and where she's going. So she can't just pick up and leave. Pretrial, what do y'all usually take? 5 days notice?
I don't think it's a certain day's notice. Just whenever she reports, she just needs to let her officer Hayes just make sure she lets her know the dates that she plans to leave and when she plans to return.
Look, she needs to give her at least 5 days notice. She knows when she plans on going to Albany or anywhere she plans on going. So 5 days notice, where she's going, where she'll be staying, and when she'll be back. And she can go. Okay?
Okay, Judge, and just a caveat to that. Sometimes there are
Ms. Ross, you got
getting her.
Miss Ross, you have a horrible connection. Horrible connection, Miss Ross. So just send in the order that she has to give pretrial 5 days notice where she's going. She has to give them a schedule where she'll be leaving, when she's coming back, and where she'll be staying, and submit that to me, and I'll sign.
Thank you, Your Honor.
Got it, Miss Ross? I guess she's got it.
I hope she heard you, Judge. I just wanted to make sure she knew that she had to process the order. That's
Yeah.
all. Okay.
Miss Ross, you got, maybe somebody can like message her. All right, can we get back to Mr. Ledbetter? You got Mr. Nash here? Okay. Mr. Ledbetter, wave your hand again. I want to make sure you're here. I gotta be. All right. So for some reason, we got a lot of people here, and I know these people aren't victims that are on here. I mean,
Judge, I am so sorry. Can you hear me? I
Miss Ross,
lost you.
no,
It's
yes.
really bad connection in the hospital.
Yep, last time. Okay. She has to notify pretrial within 5 days of traveling where she'll be going, and itinerary where she'll be staying. As long as she does that every time she travels, she'll be fine. But you got to submit that order, okay?
Perfect. And Judge, what I was trying to say before the internet connection went out, like in instances of a death, is it okay, between you and Miss Harvey, where she just submits something, shows, because she has a lot of people, one is actually in hospice now, and sometimes 5 days in advance might be hard.
Okay. Life happens. So she, she just needs to let pretrial know where she's going and stuff like that. But if she's going down there, and I say Albany, because when I was in GBI, I worked there, so it's not Albany. If you're from there, it's Albany.
I'm from Arizona, so Albany. Sorry, Judge.
Yeah, people from here know it's Albany. If you're
sorry.
From no. So anyway, she's got to let people know. Obviously, I mean, hopefully the pretrial officer has a heart. If somebody passes away, she needs to let them know she passed away in her schedule. Doesn't mean she can go for 30 days. Okay. Thank you, Miss Ross. I'm gonna get back.
Okay, thank you, Judge.
All right, Mr. Ledbetter. All right, Mr. Nash. Pretrial's position 2. This was supposed to be a short. That ain't happening. 2 CP.
I know I'm number 2, Judge. I was hoping I could get in, get out.
Yeah, 210-835. 97 days without indictment. I think it's no bond as of 7/21. Aggravated assault with deadly weapon, possession of firearm during the night, or commission of a felony. From
The defendant has no history, Your Honor.
All right, go ahead, Mr. Nash.
Thank you, Your Honor. All right, Mr. Ledbetter is a high school graduate. He graduated last May, and about 2 weeks later, he got arrested on this charge. He's 18 years old. He lives at 507 Barrington Oak Circle, Roswell, Georgia, 30075. He lives with his father, his mother, his younger brother. He has an older brother that's in the Air Force. It's an E4. He's looking to go to college once he gets out. He has no prior record. This instance is an unfortunate situation where we think he was more the victim than anything else. He happened to be in a situation where he went to get a tattoo, and the next thing he knows, he's being charged with aggravated assault. So we're asking, Your Honor, to give him a reasonable bond and allow him to live with his parents in this particular case. Thank you.
What says the state?
Yes, Your Honor. State's asking for a $25,000 good bond on count one, $15,000 good on count two. Deep concern over the nature of the charges involving firearms and shots fired. We have made contact with our victim here. The victim would not like to see, oh no, that's the wrong one. Made contact with the victim who was pressed. They would like to leave bond to the discretion of the courts. They are present at today's hearing. The victim is not present, actually. We have made contact with them. Again, we are concerned about the danger. We do appreciate the relative lack of history. Nothing further from the state.
All right, no drug unless prescribed, no alcohol, no weapons, no further contact with Jordan Livingston. Stay away from 514 Chattahoochee Circle. You can have an ankle monitor paid for by the county with a court, lawyer, and seek medical attention. Has he graduated? Did you say he graduated high school, Mr. Nash?
He did, Your Honor.
All right.
Any chance of lowering that bond like 20 instead of 40, Your Honor?
And well, so is he going to work? What's he? I mean, so he's staying with
his father has him a job, and he's working at Five Guy Burgers.
All right, so he's got to give the state and the video, then the ankle monitoring company, his schedule, where he's working and the actual location, what his schedule is going to be. He also needs to turn that over to the state. Ankle monitor will be paid for by the county. If his parents bond him out, one of the conditions are his bond. If his parents come out of pocket for any money, he has to reimburse his parents any money that they spend to get him out of jail. They can determine if he wants it dollar for dollar, if they want to give him chores to do, paying him so much an hour, but his parents have to be repaid. This is a him problem. It's not his parents' problem. He's going to have to do the grown-up thing and be responsible for paying his parents back. All right.
Okay. But by the way, he does have a 3.6 GPA, and he's an AP student while he was in high school, Your Honor.
Well, that didn't work and pay his parents back. 20 on count one, 10 on count two. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Nash.
Thank you, Your Honor. You have a great night. Bye-bye.
You too. Dantes Griffin. All right.
All right, Daniel Kane for Dantes.
There you are, Mr. Kane. All right.
This would be
So we got position 3, 22 CP 209567, 143 days with no indictment. I've got a split bond right now. Let's see. Hold on one second. There was a couple of different. Looks like there is. It's a $25,000 split bond. There's only. And I will note for this record to be very specific that there's a $10,000 on count 7 willful obstruction and $10,000 on a gang activity willful obstruction. That bond was not set by Judge Manning. You can guarantee that. All right, possession of marijuana with intent to distribute, possession of firearm.
Wait a minute, Judge. I think it's 15 on the willful obstruction.
15, apologize. Possession of marijuana with intent to distribute, possession of firearm by a convicted felon, possession of a firearm during the commission of a felony, theft by receiving stolen property, felony, possession, purchase, manufacture, distribution, sale of marijuana, hit and run, willful obstruction, and unlawful for a person employed by, associated with, or participate in criminal street gang activity. Fraud.
6 cycles, Your Honor. A 2011 conviction for robbery and a 2020 conviction out of Fulton County for aggravated assault, 2 counts. Aggravated assault with a deadly weapon, 2 counts, and aggravated assault. In addition, Your Honor, there's also a hold out of Carrollton, Georgia for an obstruction case. Nothing further to add.
Kane?
Yes, so that we get it clear, there's 5 pending charges that don't have a bond.
Yep.
So one of them is possession of marijuana with intent. The other is possession of marijuana, manufacture, distribution, sale, kind of the same thing. So that's 2. You got 2 weed cases. Then you have 3, possession of firearm by convicted felon.
Actually, there's 6.
Well, no, the hit and run's got a $260 bond, I believe. But anyway,
I'm looking at the bond order. That's what I'm looking at. The last bond order on July the 2nd. Go ahead.
all right, well, anyway, the third one is possession of firearm by convicted felon. The fourth one, possession of firearm during commission of a felony. And then the fifth one is the theft by receiving, which is an automobile.
And the sixth one is hit and run because of, according to the bond, there's no bond. So go ahead on your Ayala factors.
Yeah, well, just so you know, the jail says it's $260, but we'll say there's no bond because I wouldn't want him stuck out there. All right, so this guy, Dantes Griffin, is 28 years old. He is not on probation. Probation was over February 2022 on the ag assault. The ag assault, he got 2P, 2 years probation, and it expired on, I think, February 24th, 2020. He's 28 years old. He's a graduate of Life Christian Academy High School. He went to college at North Carolina State, I believe, for 2 years. Also attended after North Carolina Riverside Academy in Lumberton, North Carolina. He did not graduate from college, but he does have over 2 years of college. He's an electrician. He's a member of the union, EBT, I think it's called. Excuse me, it's Union 728 for electricians. He's got a job at the World Congress Center, or did have a job. I don't know if he still has it. I couldn't confirm that. I've got an address, 7615 Violin Parkway in Fairburn, Georgia, where he'd lived. So basically, we've got 2 counts for marijuana, 2 counts for a gun, a theft by receiving an automobile, and then the hit and run. Yes, the court set a reasonable bond. He's been in jail 143 days.
43 days.
Yeah, with no bond, and it's unindicted.
Go ahead. What says the state? Mr. Norwood, is that you or is it someone else?
It's 88 Highland, Your Honor.
Go ahead, Mr. Riley.
Your Honor, I just, I understand you've read all the warrants, so you know the facts. I feel like the defendant is a threat to flee. I would point out that his hold out of Carrollton, he was stopped, gave his actual name, gave his date of birth to the police officers. Once they informed him that he was wanted out of Atlanta, he then fled from the traffic stop. Officers did not pursue because they did not feel it would be safe as to where the traffic stop was. So we think that goes directly to his threat to flee. I do understand he's entitled to bond on these charges. I also feel he's a threat to reoffend based on his criminal history. I would ask for $25,000 on each of the charges that do not have a bond set. And except for the hit and run, which is a misdemeanor, I'd ask for $500. And then no contact with any gang members.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Cindy, last name Rodrigo. Stay away from 3110 Camp Creek Parkway. No further contact with your co-defendant, Jamerson McCarney. No further contact with co-defendant Ziqua, last name Pye. You're going to have an ankle monitor paid for by the county with a 24-hour curfew. You can leave for court or see your lawyer. You have 48 hours to have that ankle monitor placed on your ankle if by chance that hold in Carrollton, if they come to pick you up. All right. No further contact with anybody at the Slaughter Gang, Paradise East. Let's see, or any other gang members, and also no replicas of weapons. Stay away from 761 Violet Drive. See if I missed anything. Once again, let me get very clear that I did not set that count 8 bond. Someone else did. All right. So got count 1. Let's see how much it was. I wrote it down. 10,000. Count 2, 20,000. Count 3, 20,000. Count 4, 20,000. Count 5, 10,000. Count 6. You do it. That's 500. And then there's already 15 on count 7 and 10 on count 8.
How much on count 3?
Here's one more time. 10, 20, 20, 20, 10, 500, 15,000, 10,000. Best of luck to you, sir.
Listen, assuming he could make this bond, can he go to work?
Says the state.
Your Honor, so long as that ankle monitor is attached and he informs us, his working hours, I'm not going to object to work.
All right. He can work as long as he supplies the name of his employer or schedule and the exact location he'll be working at. He got his blood to the ankle monitoring company and to the state. Best of luck to you, sir. You can leave the booth.
All right. May I be excused?
Absolutely. All right.
All right. Good night.
Yes, both of you. Yes.
Thank you.
All right. Dominance Flanagan. Lawyer here for Dominance Flanagan.
Hello. Yes, Judge Barry.
Okay, ready? All right. Right. Let me gotta do this, right? Position 4, pretrial 22 CP 210907. Dominance Flanagan, 94 days with no indictment. Counts are trafficking in cocaine, possession of firearm by a convicted felon, possession of firearm by a convicted felon, purchase, possession, manufacture, distribution, sale of marijuana, possession of a firearm or a knife for the commission of a certain felonies, ×2. Trial.
15 cycles, Your Honor, at least 2 FTAs and 5 probation violations in the past 10 years. A 2015 conviction out of Clayton County for possession of a firearm during the commission of a felony and possession of a Schedule II controlled substance. And nothing further to add, Your Honor.
There's a 7-year probation. 7-year probation. I don't know if you're still in that probation, but go ahead, Ms. Taylor.
Judge, and I'm not sure on the probation. I think he told me that it was over since he's been in jail.
So, well, Ms. Taylor, I'll tell you that on September the 15th, there was actually 2 warrants issued for probation violation.
22, Judge.
Yes, ma'am. Yes, ma'am. And those are just outstanding on Odyssey for your information only. Go ahead with your IALA facts.
All right, Judge, Mr. Flanagan is 28 years old. Judge, a native of the Atlanta area. His mom lives and father live here in Atlanta, as well as his sister. He was living with his sister in Stone Mountain, living there because he was actually working at Checkers right around the corner. He also, Judge, and I have several check stubs, was working for a company called Road Traffic Division. They're out of Florida. My understanding is that this is a company that is hired by the cities and counties to have this guy on the road to do the flagging and all of that. Private company. He had been working with them, Judge. I have several check stubs to show. So at the time of his arrest, Judge, he actually was working 2 different jobs. I know we're not here about the charges, but he denies, he's maintained his innocence. Certainly there's a presumption of innocence. Judge, he has 5 children. He does support his children. All of his siblings, his entire family lives here. Mr. Flanagan, Judge, despite having the history that he does, he has been attacked several times. He was stabbed in the head, etc. at the jail, since he's been at the jail. He is one of the many people that have been victims of violence at the jail, hospitalized, etc. His mother actually, Judge, went in the hospital last night. I don't think he knows that and didn't want to mention that. But Judge, so he certainly has a very supportive family. He indicates to me, again, he was working 2 jobs. He'd have no reason to have any drugs or a gun on him. He was in a car, several people in the car. He told him he was just coming from work. He had his vest, everything, showing that he had been at work and was coming from work, had gotten a ride with some guys that was involved in something with somebody. But at any rate, Judge, again, he has to pass to the community. He's not going anywhere. Obviously, an ankle monitor would help with that. I think it said 2 FTAs. And now we're hearing that he's got these 2 probation violation warrants on him, so he's got to deal with that. Judge, we would ask for a reasonable bond in this situation, knowing that he has to deal with the probation violation matters. And obviously, Judge, he wants to be able to return to work. He's got children to support. Obviously, needs help and look after his mother, see what's going on with his mother. But he's stable, Judge, has stability here. So we'd ask for a reasonable bond, Judge, something in the neighborhood of $25,000 to $30,000.
What's the address where he'll be living?
And Judge, I got Stone Mountain. I'm not, Judge, if we could ask Mr. Flanagan the address.
Mr. Flanagan, are you going to be living in Stone Mountain? Thumbs up or thumbs down? Thumbs up. Gotcha. What says the state?
Yes, Your Honor. State's asking for a $90,000 good bond as is charged now. I'm showing 60 grams of marijuana per Judge Brasher's orders. That's $25,000. 15 on each possession by convicted felon, 5 on the marijuana with intent to distribute, 15 on the possession during. With respect to Ayala, we are concerned about the history. We would submit there is a significant risk of reoffending pending trial, particularly given what I'm seeing as an open probation as well as probation violations. We're also concerned about the risk of returning to a jurisdiction given the nature of the open probation and the FTAs, as well as the danger posed by the alleged possession of these substances. We'd ask for absolutely no weapons condition, no drugs without a prescription, nothing further from the state. Thank you, Your Honor.
All right. So I've got 477 grams of marijuana and 60 grams of cocaine.
Yes.
No drugs unless prescribed, no alcohol, no weapons, no further contact with your co-defendant, NHRIA, last name Nelson. You're going to have an ankle monitor paid for by the county. If you've got a hold or a probation violation, you're going to have 48 hours to have that ankle monitor placed on you. You can only leave for court, lawyer, medical, and if you have to go see your mom. I'm not going to stop you from going to see your mom, but you got to let the ankle monitoring company know and the state know where you're going and where you'll be. No further contact with the co-defendant, Richard Robinson. Stay out of Fulton County unless you're here for court, see your lawyer. And of course, you can go to the hospital if your mom's in that hospital. If she's not, nope, stay out of Fulton County. Don't even come here to get gas. All right. Let's see. All right. So 75,000 on count one, 15 count two, 15 count two, 25 on count three, 15 on count four, 15 on count five. Got that right. So six, sorry. 75, 15, 15, 25, 15, 15. Did I get all that?
So 160. That's what I'm saying.
Got that, Ms. Barb?
I got it, Judge. Thank you.
All right. Best of luck to you, sir. You can leave the booth.
Can he go to work if he's ever able to make this bond? Can he go to work and present this state at the
Right, and he's got the probation. He can go. He can have a exception for work if he just was the employer or schedule exactly where he'll be working. But he's got that probation thing. So as long as he can do that, that's fine.
And Judge, you did say stay out of Fulton County.
Yep. Plus he's here for court or to see his lawyer. If his mama's in the hospital in Fulton County, he can see his mama at the hospital in Fulton County. But he can't come here except for court and see his lawyer.
And he can't work in Fulton County.
Absolutely. Cannot work in Fulton County.
All right, Judge.
All right. Thank you. All right.
On the calendar.
Thank you. All right. Do we have Marco Hernandez? We have whoever's representing Marco Hernandez here. There you go, Mr.
Present.
All right. Position 12, 22, CP 210809, 98 days without indictment. You got 3 counts of aggravated assault, possession of a firearm during the commission of a felony, and discharging a firearm while under the influence of alcohol or drugs. Trial.
13 cycles, Your Honor, a 2013 possession of cocaine and possession of marijuana that was taken on a first offender and was sealed in 2019. And nothing further.
All right. Go ahead, Mr. Hall.
Yes, sir. Mr. Hernandez is 27. Yes, ma'am. Mr. Hernandez is 27 years old. He's born in Chicago, Illinois, but moved down here to Atlanta, Georgia with his family when he was young and has been here ever since. Obviously a U.S. citizen, raised up here in the DeKalb County school system, attended Cross Keys High School. If and when released, he would live at the address on the warrant, which is in Chamblee, Georgia, that exact street address. He is married. He has 2 children, a boy 7, a girl 2. He is employed. He has worked ever since his late teens at All Flooring, Inc. I attached a copy of the letter from his employer to the motion for bond so that everyone would have that, both the state and Your Honor. I have queued up if I need to send another copy by email, which I'm happy to do right now. So you guys have it handy because I know there's a lot of moving pieces and parts, and I will push the send button, and that's on the way to you right now, further confirming his employment. He has no felony convictions whatsoever. He has no gun charges. He did successfully complete his first offender. We don't have any FTAs announced. We don't have any probation warrants or violations announced or anything like that. Under IALA, I would respectfully submit he is not a risk of flight whatsoever. He's here. I'm in the case. We're going to see it through to the end. Number 2, not a risk to reoffend. He has nothing in his history that would suggest that anything of this kind of charges have been brought against him, which are just allegations at this point, are something that he does or is likely to do again or anything like that. He's not a danger to the community for the same reason, and no risks to witnesses whatsoever. Obviously, I'm glad to stay away from whomever. This is a case in which he's been in jail for 97 days. So under OCGA 17750, he's entitled to a bond. I'm not going to belabor the point, Your Honor, because I understand you already said preliminary hearings are in the morning, motions are in the afternoon. Bonds in the afternoon, preliminaries are in the morning. Let me just say to you, we filed on July 20th, 2022, a motion request for preliminary hearing. It's yet to been scheduled. We haven't, much less actually had it. Had we had a preliminary hearing, I would have expected, based on my investigation,
to, among other things, show that Mr. Hernandez was the victim, not the perpetrator has been alleged. 2, that one of the alleged victims shot another one of the alleged victims, not Mr. Hernandez, and one of the alleged victims wasn't even present whatsoever. And there's a third unidentified person who's not listed among the victims who started the whole thing with a firearm. Obviously, we can't decide that all today, but the significance of my points is this. He's been in jail for 97 days based on the kind of one-way traffic of the state's allegations without any opportunity to address them or push back on those. And that's why both the legislature and the Supreme Court of Georgia have said it's so important for him to have a bond at this point. It's not even been presented to a grand jury. So for those reasons, Your Honor, I would respectfully request, and also let me just say, I know the hour grows late. I am one of the people, I have Ms. Daniela Avila online. She's one of the people you said, well, there's a lot of people here. She is prepared to speak, testify. I understand the court's instructions were only witnesses. She's the only witness who's on here. I'm happy to have her speak to the court, and that was my plan. If you'd prefer, I just proffer what she's going to say. She would confirm the things I've already told you, including that Mr. Hernandez is a loving husband, supportive father, that he works full-time to support the family. He has a job waiting for him per the employer letter I attached to the motion I've already sent over to you. Sometimes I find it helpful for courts to hear directly from the witness, but I understand that we are now at 6:27 p.m. And so would the court like to hear from Ms. Avila or just keep on rolling?
Nope. What says the state?
Yes, Your Honor.
I'm sorry, go ahead, state.
I really just hear from the victims on bond. So go ahead.
Yes, Your Honor. The state's asking for 30,000 on each aggravated assault, 15 on the possession during, 5 on discharging firearm. That's 110 total. We are concerned about the danger posed to the victims here. I do have a summary of our victim contact, pulling it up right now.
So, Judge, I would like to be able to address what I think is appropriate bond at an appropriate time. And I would object to him if we're not doing facts. If we're going to get into facts, that seems like that's a preliminary hearing matter.
One of the victims, Your Honor, we have made contact with. They do not wish to see this defendant receive a bond. They are concerned for their life and safety. Here it is. Hezekiah Howard. Roxana Lara attempted contact, unsuccessful, left voicemail. Jean Granado spoke with victims, stated they would not like to see the defendant return to the streets. They are not present at today's hearing. With respect to Ayala, again, there is concern about the danger to the community as well as some risk of reoffending, given the nature of these charges. We would ask for a stay away and no further contact with all victims, nothing further from the state.
What are your numbers, Mr. Hall? Thank you.
5,000 good bond, 5,000 good bond, 5,000 good bond, 2,500 good bond, $1,000 good bond, which is on the misdemeanor of the last count. Happy to do the ankle monitor, no problem. We would like him to be able to work. I've already provided proof of work multiple times.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3222 Peachtree Road Northeast. Actually, he lives in Shelby, so he can stay out of Fulton County. This is here for court or to see his lawyer. Ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, employer, as long as he supplies the name of his employer, schedule, and exactly where he'll be working. No further contact with Roxanne, last name Lara, Lara. No further contact with Jean Granados, Granados, and no further contact with Hezekiah, last name Howard. Once again, that ankle monitor will be paid for by the county. 25 on each ag assault, 15 on the possession of a firearm during the commission of a felony, and 3,000 on the last count. 25, 25, 25, 15, and 3. Best of luck to you, sir. You can leave the booth.
I'd be excused, Your Honor.
Yes, sir. All
Good
right.
to see you, Your Honor. Thank you.
You too. Timothy Hickson.
Good afternoon, Your Honor. Ben Gutierrez here on behalf of Timothy Hickson.
All right. Position 10, 22 CP 210974. Timothy Hickson, 91 days without indictment. You got trafficking cocaine, possession of marijuana with intent to distribute, possession of firearm by a convicted felon, possession of firearm during the commission of a felony. No bond as of July 27th. Trial.
31 cycles, Your Honor, at least 4 FTAs and 4 probation violations in the past 10 years. A 2012 conviction for purchase, possession, and sale of marijuana. Also appears to be on probation for possession of a firearm by a convicted felon, possession of cocaine, theft by receiving stolen property. Sentenced March 30th, 2022 to 5 years probation. That's out of DeKalb County. And in addition, Your Honor, there is an open case out of Fulton County under 21 CP 204-303. That's for theft by taking, felony and battery, family violence misdemeanor. Nothing further, Your Honor.
All right, go ahead, counsel.
Thank you, Your Honor. Your Honor, Timothy Hickson is 34 years of age, was born and raised here in the metropolitan Atlanta area. There's nothing Your Honor should fear regarding him being a flight risk. He'll come to court when required to do so. I believe some of those FTAs that were mentioned by pretrial judge were not for him missing court, but for him not receiving notice at his home for court. Judge, he's a former high school athlete, played football for Grady High School, played tight end on offense, played defensive end on defense, was an above average student, had a B average until tragedy befell himself and his family, addiction. He is the eldest of 5, the nucleus of the family. He is still the nucleus of his family. Everything revolves around him. Judge, he has a community of support behind him. Most of the people tried to log on to the other website to be able to stream, Judge, but they were unable to. So I have to apologize for the number of people. I asked them then to, if they could, just log on to this and turn their video off as well as mute themselves. They wanted to observe the proceedings. I understand the court, and I understand the time, Judge, so I'll speed it up. I would ask that you hear from his brother, his stepmother, as well as Pastor Elder Mark, who has a program that he can speak to you about people who are trying to get their lives back on track, who've had similar backgrounds to Mr. Hickson. What I was saying, Judge, regarding his background, his mother was addicted to drugs. She went to jail for 6 months while he was in high school. At that time, his life took a drastic turn in a different direction. He was required to clothe and bathe his siblings, take them to school. By doing so, he sacrificed his education and his future. He then had just started working after the fact. I understand you heard his cycles and his criminal history, Judge, and that is from, unfortunately, him feeling that, the only way to provide for his family was to dabble in the streets. He has since learned his lesson. I understand the charges before, Your Honor. I'm not going to go into those. However, I would like the court to know that we believe that a motion to suppress will be dispositive of the case. That being said, Judge, he feels now that he's let his family down. He is a father himself, father to a 16-year-old daughter. His brother, Mr. Brennan Stewart, who I hope is on the call, he is, Mr. Brennan Stewart, Judge, has now taken custody of his daughter while Mr. Hickson has been in custody. He's been in here 91 days. The past month and a half, his brother, unfortunately, has had to take custody of his daughter. The mother no longer wants custody and has handed it over to Mr. Hickson. Because of his incarceration, he unfortunately was unable to take his daughter in. And so she is now, luckily, with Mr. Stewart, who, Judge, is only 30 years of age and has no children of his own. He is actively and eagerly hoping that Mr. Hickson can be released so that he can take over and resume his parental responsibility for his daughter. He does have a relationship with his daughter better than the mother does. I believe she's going through a rebellious teenage period now, and she needs her father, Judge, in her life. That being said, Judge, he began working with his grandmother, washing dishes at Hopewell Baptist Church, while she provided bakery services to the members. He has experience in construction. He's done everything from popcorn ceilings to caulking and drywall. He was last employed with Alpha Installation and Waterproofing in Cobb County. Not sure if he'll be able to go back to that work where he tarred, he made sure the drains were properly cleaned, and he laid down foam boards. But the good news is that his brother, Mr. Stewart, Judge, owns a restaurant and says that Mr. Hickson can come and work for him. I don't know what the fee will be, but I don't believe that it'll be a big deal for Mr. Hickson to be grateful to be able to have been given a bond and to show the court that he is willing to work and not violate any conditions that the court might set for him. So, Judge, just very briefly, his daughter needs him at home. He does have employment at his brother's restaurant. He's afraid of being assaulted at the Fulton County Jail. He's had several threats that had to be moved. I'm sure Your Honor's very well aware that the jail has become very dangerous in the past recent year or two. And so Mr. Hickson is very concerned for his safety. I don't have to remind the court, Judge, he is presumed innocent. This is a pretrial detention without any finding of guilt. He's not a risk to reoffend. I believe proper measures can be put in place to ensure he returns to court when requested to do so, to ensure that he does not commit any felonies or any other future crimes while he's out on bond, Judge, and to make sure that, well, there are no victims in this case where intimidation should be considered. Would Your Honor allow Mr. Stewart to speak very briefly?
Not right now. Let me hear from the state, because I want to hear about this. There was 117.4 grams of cocaine, 1 pound of marijuana. What says Mr. Norwood?
Yes, Your Honor. I'm showing 31 cycles. I'm showing a felony conviction involving controlled substances in March of 2022. State's asking for $40,000 good on the trafficking in cocaine, $10,000 good on the possession of marijuana, 15 and 15 on the firearm charges. State is concerned about the danger posed to the community with the alleged possession of these controlled substances. Based on the record we would submit to Your Honor, there is a strong likelihood of reoffending pending trial, given the nature of the multiple felony convictions involving controlled substances. Nothing further from the state. Thank you, Your Honor. We would, of course, ask conditions as Your Honor sees appropriate and reasonable, including no drugs without a prescription, no firearms.
Counsel, he's still going to live in Decatur, right?
I believe he now will have to live with his brother, Judge. I believe he's lost his housing.
Sorry, where's his brother live? Fulton County, DeKalb County, Gwinnett County? Where's his brother live?
Mr. Stewart, could you, yes, sir. Turn your video on, please, sir. Yes, sir. Where do you live?
DeKalb County.
Thank you, sir. All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 3044 Kentucky Court in East Point. You can have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical work. If you supply the name of your employer, the location you're going to be working, and the schedule. Stay out of Fulton County unless you're here for court or to see your lawyer. All right. 30 on count 1, 15 on count 2, 15 on count 3. Wait, excuse me. 30, 20, 15, and 15. 30, 20, 15, and 15.
Your Honor, I understand that you're indicating that he should not return to Fulton County. If
unless he's here for court or to see his lawyer.
Regarding childcare, is that possible? He has multiple children. He goes and picks them up from where they stay with their mother, not just the 16-year-old. He has other smaller, younger children. Regarding being able to go and pick them up, spend time with them, is just a ban for Fulton. I'm just trying to get an understanding, Judge, so that he understands the conditions of the bond.
How many children does he have, and how many live in Fulton County? I mean, I do divorces. Sometimes why can't mom meet him with a child?
If that's the court's order, then Judge, that's what you'll do.
They could meet right outside the Fulton County line and exchange the child.
Yes, Your Honor.
All right. Best of luck to you, sir. Is Mr. Melnick make it?
Not yet, Judge. His last email to me says he's 15 to 20 minutes out.
All right. Let's see. Do we have Cecil? Is it White? All right, Ms. Taylor. All right, position 5. And then we'll get this one and the one for Mr. Melnick, the only 2 in custody. Sorry, at South Annex. We'll take up those motions. All right, position 5, pretrial 22, CP 210910, Cecil White. Sorry if I mispronounced that. Theft by receiving stolen property, expired or no driver's license, possession of marijuana less than an ounce. No bond as of 7/23/22. Bro.
4 cycles, Your Honor. 2 open cases out of Fulton County. Case number 22 SC 183060. That's aggravated assault, possession of a firearm during the commission of a felony, and theft by taking, and simple battery family violence. Also, case number 22 CP 208098. Possession of a controlled substance 1 or 2 with intent to distribute, possession of marijuana with intent to distribute, possession of a firearm during the commission of a felony, and possession of controlled substance, Schedule 2 with intent to distribute. And nothing further, Your Honor.
All right. Go ahead, Ms. Taylor.
Thank you, Judge. On behalf of Cecil White, Judge, while he does have 4 cycles, Mr. White has no prior convictions, Judge. The situation with Mr. White's, Judge, is that he is very ill. He is 35 years old. He is married, been married for 5 years. His wife on streaming live. His mother and sisters and other family members are also involved, Judge, in this case. I had sent over to the court and had previously sent to the district attorney's office some medical information on Mr. White from Emory Winship Cancer, from his doctors over there. Very, very concerned about his health. That he, and the doctors actually said that it's danger to him to even be in jail. And he's been in jail now, Judge, about 30 days, about 90 days or so. He is very ill. He's disabled. This is a theft by receiving case, Judge, of a firearm that he says he bought at a gun show. And I know the court has seen the warrant, so we obviously presume that. But this is a theft by receiving charge. Judge, this man needs a reasonable bond so that he can primarily get medical treatment. He is housed in the medical unit at the jail. He's supposed to be getting certain medications 3 times a day. He is not getting that. Medicine that he is on is extremely expensive, and the jail cannot provide it. So he is in very, very poor condition, Judge. So this is really I'm begging you on behalf of his family and Mr. White for a reasonable bond, because this man is very sick. He's very ill. He would be, Judge, according to his wife, living back with her. I don't know about these. I heard the charges regarding family violence, battery. Like I said, he's not been convicted of anything. But she says that he would be living with her. But if not, just so that he can live with his mom, sister. They said they want to send me out this medical information. I did, like I said, try to forward it to the court. I had previously forwarded to the state and trying to get them to consent to a bond on the theft by receiving charge. And I never got a response from them. Ms. Parish, and I think she indicated she sent it to her supervisor, Mr. White, and nobody never responded. We were asking for compassion here because this man is very ill.
All right, is he going to be living in Fulton County?
Yes, Judge, he does live in Fulton County.
What does the state?
His family lives in Fulton County as well. Judge, all of his family, I believe, lives in Fulton. I'm not mistaken. They all live in Fulton County. The mother, sister, I'm not positive.
All right.
Yes, Your Honor. We're asking for $7,500 good on the theft by receiving. We'll submit to Your Honor, it's a gun theft. We are concerned about the danger posed to community with these allegations and the property to the victim. We'll ask for $1,000 on the remaining charges. There does also seem to be some risk of reoffending given the nature of the open cases. We'll ask for absolutely no weapons condition here, stay away, and no further contact with the victim. I have the name.
There is no victim, Judge, in this case.
It's a gun show type of situation, Your Honor. But yeah, it's nothing further from the state, and I'll put on the record, I am willing to coordinate that consent. I can follow up with any documentation. I haven't received any, but if it's sent to me, I can see what I can do.
It was sent to your office, to Ms. Parish and to Mr. White, and that was sent way back when you first got arrested. And I did send it over to the court today.
Gotcha. Isn't there a fine in City of Atlanta? Is it $50 for a simple possession? Is that what the fine is, City of Atlanta?
Yeah, it's like, something like that.
Yes, Judge.
In like $50. All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with ALLANTE, last name Lynn. Stay away from 2841 Greenbrier Parkway Southwest. No driving until you get a valid driver's license. You say it's going to be living in Fulton County. You're going to have an ankle monitor paid for by the county, court, lawyer, medical, work, as long as you supply your employer on a schedule. Theft by receiving stolen property, $7,500. No driver's license, $250, and possession of marijuana less than an ounce, $50. $7,500, $250, and $50. Best of luck to you, sir. You can lead the booth.
Thank you, Judge.
Thank you. So the one person got to wait to get Melnick in here. Let's see. That's taken care of. All right, let's see. These over here in my hand. All right, so All right, Mr. Rucker, I got position 19 free trial, not Mr. Rucker as the. Oh, okay, they're both Rucker. Mr. Rucker, for Mr. Rucker, 22 CP 210257, Ryan Rucker. Aggravated battery, there's a $50,000 good bond, and right now he's wanting to modify his conditions of a bond. Anything I need to know pre-trial?
No, Your Honor.
All right, go ahead, Mr. Rucker, Clinton Rucker, not the other Rucker.
Yes, good evening, Judge. How are you?
Doing well. It's good to see you.
Good to see you too. Wait till I tell Judge Oliver how hard you're working.
There you go. I'll do the same for you.
Let me tell you, Judge, we are coming before the court. My client is on the platform, as well as the listed victim in this case, Miss Edgehill. I want to tell the court that Judge Frazier was kind enough to grant him a $50,000 bond back in June as a result of this aggravated battery charge. These two folks, Judge, to be quite honest with you, are just in love. And they were engaged at the time of this incident. This was an argument that just spiraled badly out of control. Alcohol was involved to some extent. But through third parties, what I have learned, and the reason why I'm here this evening, is to ask the court to modify some of the conditions of Mr. Rucker's bond to allow him the opportunity to reconcile with his fiance. It's what he wants. It's what she wants. They have a 4-year-old child together. He is the sole breadwinner. I'll share with the court that Ryan Rucker is a member in good standing of the State Bar of Georgia. He's actually a practicing attorney. He started his career out with the Fulton County Solicitor's Office for several years. He's been in private practice for a number of years, doing mostly personal injury work up in the Buckhead area. And so they share expenses. He takes care of the entire family. They want to be able to go to counseling together. They want to be able to parent the 4-year-old together. They basically want to reconcile, but based on Judge Frazier's orders, and I understand it at the time, everybody wanted to figure out what was going on. He put no contact orders in place for them unless they went through third parties. And so that's why we're here before the court. It's been some time. There's been no other incidents between these two folks. And I did reach out to Ms. Edgehill to ask her to participate as a victim in case the court wants to inquire of her directly.
All right. Let's see. Ms. Edgehill, where you at? If you take yourself. Ms. Edgehill, you got to turn your camera on. I have to see you. Raise your right hand, ma'am. Do you swear or affirm testimony you're about to give is the truth, whole truth, nothing but the truth?
Yes, I do.
All right. Straight to the point. I'm smarter than I sound. Are you in fear for your safety?
No, I'm not.
Are you telling me that you want no further violent contact with Mr. Ryan Rucker?
I want to be able to reconcile our family. I don't fear anymore. I don't fear any violence.
Okay, so you want no further violent contact with Mr. Ryan Rucker?
Right.
Yes. Yes.
Okay. Anything from the state?
The 88 Roth.
88 Melissa Roth for the state judge. Your Honor, just to give you some context, I know Attorney Rucker alluded to the fact that the defendant was a former prosecutor. The state's concern is that that apparently was one of the threats that he used to keep Miss Edgehill in control, was that he was a prosecutor and attorney, and that he would win custody over their son if she ever made a police report. Miss Edgehill at the time of the offense told officers that that the defendant, Mr. Rucker, had been physically abusive to her numerous times previously. And so those are the state's concerns, Judge. I'll leave it in the discretion of the court. If the court is inclined to allow them to have contact, Your Honor, I would ask that the court consider perhaps adding terms such as that the defendant is not to consume alcohol, as Attorney Rucker indicated. This incident did involve the defendant's use of alcohol, and that is perhaps what fueled at least part of the incident starting. Other than that, Judge, I would submit to the court.
So, Mr. Clint Rucker, is he planning? Are they planning on living together right now?
I think, Judge, that is the hope. I think they want to be able to live together. Ms. Edgehill lived with Mr. Ryan Rucker for a few years prior to this incident. They occupy a condominium at 3669 East Paces Ferry Walk in Atlanta, Georgia. You know, for financial reasons, more than anything else, it's just prohibitive at this point for them to continue to live in two separate domiciles. Mr. Ryan Rucker provides those finances. And I will state to the court, in addition, there's been no movement by Mr. Ryan Rucker to seek custody of the children. There were other lawyers involved in this case, you know, because at one time, initially, there was a contemplation of child custody and child support. All those things have been suspended at this point. There was a TPO that was put in place and that was voluntarily dismissed back in July the 22nd of 2022 by Ms. Edgehill. And so I say, Judge, that I understand the state's concern. Of course I do. But I think these folks, with the help of some family counseling and maybe just a little bit of prayer and some support with their family members, they might be able to put this thing back together. They're so young. I asked the court just to give them the opportunity to be able to do that and pull their family together.
All right. No drugs unless prescribed, no alcohol, no weapons. I'm adding that to it. No further vital contact. Mr. Rucker, I think you've got to send that in, if I'm right, Ms. Parham. And you got to put, I want it especially in there that Ms. Edgehill appeared and testified herself. Ms. Edgehill, are you planning on the two of you living together right away? Take yourself off mute, ma'am.
I think if we're allowed, we want to like do counseling. I know that that's what I want for me and my son and for him.
Edgehill, hold on. Listen to my specific question. Do you plan on living together right now?
If we can, yes.
All right. So I'll put that and that you no further violent contact and for the purposes of counseling too. So yeah, just put that in there and send it to me, Mr. Rucker. But I'll tell you this, and Mr. Clint Rucker can tell you, there's Ms. Edgehill, there's nobody that's less impressed with somebody showing up that's allegedly committed acts of family violence, say, well, I'm a cop or I'm a lawyer or I'm a judge, because that does not impress anyone on the bench when you're supposed to know the law. And when you use that to threaten somebody, if you do by chance, it less impresses them even more.
Yep.
And I assure you, Mr. Ryan Rucker, that it won't impress me. And if there's a divorce, I'll probably hear it. All right. You shoot that order to me, Mr. Rucker, and I'll get it signed. Okay.
Yes, ma'am. I sure will. Thank you so much, Judge. I appreciate it.
All right. Stay healthy and safe. All right.
You do the same.
All right. I got position 20, Sean Ivory. It's 22 CP 208441. There is aggravated battery obstruction of law enforcement officer, and this is a motion to modify bond. Is this yours, Ms. Jones?
It is.
And I'm sorry, Judge, but we are formally excused. Is that correct?
Yes, sir. All three of you. Yes, sir. So, Ms.
Thank
Jones,
you so much.
Are you just wanting him not to have to pay for the ankle monitor anymore?
No, the ankle monitor is paid for by the county, I believe. He would like for the ankle monitor to be removed so he can travel to Ohio to get medical services done. He has teeth issues and it costs less in Ohio. He's giving me a place where he's going to be.
All right. So, Mr. Norwood, I mean, how long is he going? I mean, what? I'm saying, how long is he going to Ohio?
I was checking to see if he has to pay for the ankle monitor or not. He is leaving as an appointment if he can make it for October 27th. They have several teeth that need to be pulled out. There's not a definite date back, but I can give you the address of where he's going to be at is 3527 50th Avenue in Cleveland, Ohio, if he can actually make it. The dentist did not give us information 100% since he's in Georgia, and we don't know if he actually can go up there to travel. But he would ask for the ankle monitor in itself to be removed altogether. He is on the line, Your Honor.
I think it was just put on in June and it's paid for by them. But Mr. Norwood, if he's going up there to have teeth pulled, is he planning on moving or just going up? Mr. Ivory, turn your camera on.
Hey, how's it going?
She said camera on, you didn't have to respond.
All right. So, how long does if he's having teeth removed, how long does he plan on being there, Miss Jones? Because Mr. Norwood, do you know anything where he can travel with ankle monitor as long as he let them know? And
I could go.
I'm not certain of any arrangement like that.
Hi,
I
how's it
read
going?
the motion and was looking for some additional details as well. But I'm not certain of how that arrangement could work at this juncture with the conditions on the bond.
So he can travel. So, Mr. Ivory, stand by, sir. So he could go week, 2 weeks, whatever he's doing up there, get his teeth done and come back. As long as the ankle monitor company knows where he's at. And yeah, it is paid for, so he doesn't have to pay for that. Or what's your position on getting it removed? Because he's got obstruction, he's got an aggravated battery.
We would object to removing it due to the nature of the charges. But as far as the reasonable modifications with respect to the dental issues, we would leave that in the hands of Your Honor.
Because it looks like, I did a whole stay out of Fulton County, stay away from MARTA. Boy, stay out of Fulton. Yeah.
And to my understanding, he's been abiding by everything, and that's why we filed this motion. He has not tried to leave or do anything. We wanted to get order from the court before doing anything and to speak into the court, but he has been abiding by everything, Your Honor.
I think that's what it was that allegedly broke the victim's eyesight. And I tell you what, he can travel up there to get his appointment. You can put it back on again, and we could try to talk about removing it. But right now, he can travel. He needs to get you the dates of his travel, and when he's coming back. As long as he lets the ankle monitor company know, keeps that thing charged, he should be good.
Okay, so you're allowing him to travel. We have to give him the dates, and we just have to let the ankle monitor people know.
And the state, the dates, where he'll be, the address where he'll be, and definitely the dates there and back.
I will send that in, Your Honor. Thank you.
All right. Thank you. All right.
Please.
Yes, ma'am. Yes, ma'am. All right. So we got, all right. Let's see. Christine Brown's indicted. It's indicted. Hold on. Let's get through this. First case. All right. We got, let's remove. All right, so we got, so there's 2 cases for Mr. Hilliard, right, Mr. Sharp? I got positions 22 is 22CP08370, Charlton Samuel Hilliard, the third theft by taking. I got 2322CP208371, Charlton Hemp Samuel, the third, aggravated assault and armed robbery. What's this? Oh, all right, so my note says you want to modify the bond so that he can get employment. Am I missing anything else, Mr. Sharp?
Yes, Your Honor, that's it. You granted him bond about 2 months ago, and he's been doing well. There's some mental health history with Mr. Hilliard, and he's been doing well. He's been seeing a psychiatrist and a therapist, and his mother and him both are concerned his life is stagnant at this point. He does have the ankle monitor. He's maintained, he's been in good contact with the ankle monitor company. He's been following all the rules, but his mother believes that he can obtain employment at Publix. They hire through the National Association for Mental Illness. And she's looked into that. However, I hear Your Honor saying that we need to, on previous cases, you would like a schedule. But the reality is he needs permission from the court if the court sees fit to even go through the interview process and all of those things to obtain employment, and then later on to get his schedule.
All right. Pre-trial, is there anything I need to know?
No, Your Honor.
All right. So what I hear you saying, Mr. Sharp, is that he's going to have an interview process And, but is that something, if he's have an interview, he can let them know, I got an interview on this date? He can let the ankle monitoring company know?
Well, I think the first step would be go to the site and start applying for jobs. He's hoping for Publix, but there's also a local warehouse that is supposedly hiring per his mother, who's also on the call. And so he's just asking for some leeway to seek employment and then eventually provide his schedule.
All right, what says the state?
I'm reading the motion now, and it says that he is anticipating likely obtaining employment at the Publix by his house. The state has no objection, of course, if we have all of the hours and documentation, but as far as
there's no
leaving the house,
documentation.
I'm not certain if like how that's gonna be worked out with the ankle monitor. But if we can see when he's going to Publix for interview, and then the Publix provides a schedule, that there's no objection at all to employment.
Yeah, so I guess what he's wanting to know, Mr. Short, if he gets an interview Thursday, he just says, hey, let's the ankle monitor go into an interview. And then you let the state know he's going to an interview. And I understand there's interviews. And just so you know, Mr. Hilliard, Mr. Short, Chipotle's hiring, they're offering like a $3,000 signing bonus. Every day I drive by that place. $3,000 signing bonus, just in case. In case you're looking, Mr. Short.
There you go, Mr. Hilliard.
In case you're looking too, Mr. Short. But so that's out there. But as long as, he's going to know when he's going to have an interview. So as long as he tells them, and then he says, lets the ankle monitoring company know. Then when he gets a schedule, he just has to tell them the schedule and the location he's going to be working.
Okay, so if I'm correct, Your Honor, he doesn't have an interview scheduled because the first step is to go to the location and talk and do the lead into the interview. So my understanding from what you're telling us, Your Honor, is just stay in communication with the ankle monitoring company.
And just send me that order that to go apply an interview, just have to stay in touch with the ankle monitor and also let the state know and you're good. And everything that I do when it's employment, where he's working and a schedule, and that'll be good. Let the ankle monitor company and the state know. That way, if the state gets his ankle monitor and he shows that he's away, they'll know where he's at. But you can do that on both cases. His ankle monitor is paid for out of worker money, right? I was just trying to.
It is.
Okay. I just want to make sure he's not paying for it. I know that it can be expensive.
I appreciate that, Judge. So is the ball just procedurally, the ball's in my court to write that order?
Yeah, that's what that's what Dexter Douglas says, and then just submit it. You can shoot it to me and to the clerk.
Okay, thank you very much, Your Honor.
All right, thank you. So
That'd be excused.
Absolutely, and you too, Mr. Hilliard. Good luck to you. So,
thank you,
Mr. Beverly. I thought you heard at the beginning. I'm sorry you've sat there the whole time. I could have been looking at you, but your case was indicted.
Okay.
I thought we sent email out that it was, but yeah, that was indicted. I'm sorry. I should have said something.
Okay. Is the court willing or able to entertain a bond motion at this time?
Yeah, you got to go to who it's assigned to. Let me give you the SC number.
That'd be great.
All right, let's see. Hold up. Okay, that's 22 SC 184583. And let me see. Hold up. Judge Krause.
Is that Kraus?
Yes, sir.
And, thank you. And Norwood, are you able to tell me what 88?
Yeah, let me call you back.
It's Dion Peoples is in Judge Krause.
Okay. Well, thank you all very much.
All right,
Maybe a different one though, but yeah.
I'm sure they could let you know. If somebody else gets there, you can probably email Judge Krause's case manager may know if there's somebody else handling it. All right. So I got Miss Rockwell. Miss Rockwell, Christina Brown was indicted. Are you just hanging out, Miss Rockwell?
Her was indicted, but I am hanging out, and I want to be.
Okay.
Because I have a medical emergency, not me, but a client of mine whose mama just got hospitalized. But I'm talking to Miss Roth about it, so I'm gonna stand down, Judge.
Okay. So we've got Let's see, who else do I have? Any other? So I just have Mr. Melnick. We're still waiting on Mr. Melnick. DeKalb County. Ms. Robinson.
No, Judge, I knew you were gonna go there. I was already ready with the unmute button. No, Judge. Nothing to be said about DeKalb County, but wonderful things.
That's true, but they know what time it is in DeKalb County that they're keeping this man this long? In South Annex, I think South Annex is going to go over there to DeKalb County and stir up some trouble. Lieutenant McDonald's liable to go over there to DeKalb County and stir up some trouble.
Your Honor, Lieutenant McDaniel is gonna bring us dinner.
He should. He can order it and have it delivered.
You forgot, Your Honor, tomorrow I'm going out of town.
Oh, yeah. Maybe Mr. Melnick will buy dinner for everybody.
He just came in.
Oh, see, look, we conjured him up. So we'll put that on the record, Madam Court Reporter. Mr. Melnick is buying dinner for everybody left on the screen. Oh, sorry, hang on. All right, Mr. Melnick, we got D'Amica Arville Malcolm, 22 CP 210 740.
1 minute. I literally just walked out of jury selection. So if you'll bear with me, you can let pretrial do their spiel first and just bear with me for a second. I will be ready.
All right. I'm not even going to ask which judge kept you this long because it doesn't matter, but you can message it to me now. All right. 99 days. 99 days, no indictment, aggravated assault, possession of firearm during or attempt to commit certain felonies, reckless conduct. Trial.
4 cycles, Your Honor, an open case out of Fulton County for theft by receiving stolen property, obstruction of a law enforcement officer. That was a misdemeanor. Reckless driving, that's under case number 22 SC 183116. There's a case in judicial hold under case number 19 SC 173359 for armed robbery, aggravated assault with a deadly weapon, and possession of a firearm during the commission of a felony. And nothing further to add, Your Honor.
Yeah, so it looks like it's got a date in there. It's like there's a 11/22 is final plea. Trial set for 1/9/2023. Looks like that's kind of like in the hopper, right, Mr. Nolan?
Yes, Your Honor. I can
Yeah,
take a closer look at that, but I'm seeing 3 open cases. Yes.
Yeah. Mr. Melnick, whenever you're ready.
Thank you, Judge. If you will, just bear with me for 1 more second as I get my notes up here.
I'm sure he's ordering you dinner at South Annex, so just let him order dinner.
Thank you, Your Honor.
So, Judge, based on what pretrial just announced, I don't believe Ms. Malcolm has any prior felony convictions. She was living in Atlanta. Her mother lives here. She has other family members that live in Atlanta as well. As far as the case that is in judicial hold, I have spoken with the case manager about that case, and there was a question with regard to notice. As you indicated, I believe that the judicial hold matter has been resolved. She's been in custody for 90 days. She has no prior felony convictions. State has not taken any action on this case. They've just sat back and let the 90 days take its course. I don't know anything about the alleged victims in this case, but from what Ms. Malcolm has told me, it's not anybody that she knows. It's nobody that she's ever had any contact with previously. I'm just asking that you grant her a reasonable bond, Your Honor. I think $50,000 total bond would be a reasonable bond in this case.
All right, what says the state?
Yes, Your Honor. The state has deep concerns about this case with respect to the danger posed to the community and to the victims, as well as the risk of reoffending pending trial, given the nature of the history. We have made contact with our victims. We have 2 victims. Both are on the call right now under the last name Harvey and under the last name Alexander. I have a statement to read from one of the victims. Our victim witness advocate was going to read it, but they had to catch the shuttle. So if Your Honor doesn't mind me reading it, I have it ready to go right now.
Go ahead, Mr. Norwood. Unless you want pre-trial to do it, go ahead.
This is on behalf of the victim with the last name Harvey.
Okay.
Good evening, Your Honor. It has come to my attention that the defendant is trying to obtain a bond. It saddens me that the defendant is trying to walk the streets freely with no repercussions for her actions. I understand everyone deserves a second chance, but when people are evil-hearted and careless with their actions, they should be held accountable to a certain extent to where they are forced to follow the law. I am aware that this is not the first time the defendant has tried to take someone's life. Please take in consideration that I have not been the same since the incident took place. I have nightmares and I seek counseling. I still walk around in fear, knowing that her two accomplices have not been detained. I have moved back in with my family out of fear of this happening. Releasing the defendant gives no guarantees that she won't commit the same crime again. And this time it turns deadly with someone's life being taken. Furthermore, my 7-year-old son still has nightmares from the defendant's actions. He was home at the time of the shooting, seeing bullet holes through the walls of our home that he will never be able to erase from his eyes. I am asking that the court takes in consideration the trauma that this violent experience has caused my family. The defendant is a menace to society. I have a note on the other victim as well. I'm pulling them both up. They might have been on the other email. One second. Yes, spoke with victim. She would not like to see the defendant receive bond. She fears for life and safety. That was the drafted written statement. The second victim, Alexander, stated she would not like to see the defendant receive a bond. She has enrolled herself in counseling as a result of the incident and fears for her life as well as her safety. Again, given the nature of these charges, I'm asking for a $40,000 good bond on the aggravated assault, 15 on the during, and we'll do 2,000 on the reckless conduct. Of course, with conditions, absolutely no further contact with the defendant, stay away from the incident location. And of course, no weapons, no drugs without a prescription, and any other further conditions Your Honor sees appropriate and reasonable, including an ankle monitor.
And what'd you say on count one?
40,000, Your Honor.
Is she gonna live in Fulton County, Mr. Melnick?
Ms. Malcolm, I do not have your address right here in front of me, and I'm sorry about that. As you know, I'm in the middle of a trial right now. Will it be Fulton County?
Yes, sir.
Okay.
All right. All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 500 McDaniel Street. No further contact with Octavia Harvey. And the other victim's name, Mr.
Taisha Alexander.
And no further contact with Taisha Alexander. Going to have an ankle monitor paid for by the county with a 24-hour curfew, except for court, lawyer, medical. And I don't think I heard anything about if any of these, if the other case, there's your judicial hold. So if something comes up with that, or the other case, you have 48 hours after being released, whatever's going on with those, to have that ankle monitor placed on your ankle. And make sure you give an updated address to the clerk's office and to the court. 40,000 on count 1, 15 count 2, and 2,000 on count 3. 40,000, 15, and 2,000. Best of luck to you, ma'am. Thank you, South End. Next. Yes, Mr. Melvin.
Thank you, everybody. I appreciate you waiting for me. And it's Judge Corsi, in case you're wondering.
Ah, look at that. See, Miss Robinson, I knew who it was.
All
right,
right.